Hi guys, welcome. Got a small group tonight in person, and also welcome to our online viewers. I'll give you guys a welcome as well. For those of you guys who are here and then also online, if you have any questions during the seminar, there's a Q&A chat box on the webinar that you guys can type those in for James. And at the end of the night, we'll have about 15 or 20 minutes of Q&A. Obviously, for guys that are in person, you can ask here. And for those online viewers and guests, you guys can type those in the chat box for that. Welcome to tonight, guys. So tonight is a Community Hub sponsored event. For those of you guys who haven't heard about the Hub, we, through Southview Church, have been given a grant by the government to basically host nights like tonight. And it's to do with mental health, financial literacy. We have tutoring for kids after school twice a week. And it's just been a really cool program to give opportunities and use the church space for the community, especially as COVID happens here and starts to come to an end. So tonight we have James Bilcox. He'll come up in a few minutes. And James is a certified financial planner, and he's worked in financial services in Calgary for over 20 years. And tonight he's going to be talking to us about wills, power of attorneys, those kind of things to be planning for the future. He has spent a lot of his career with ATB Financial, RBC, and the last 9 years with Sun Life, which he'll touch on today. He runs Searchlight Financial Solutions and collaborates with clients on financial strategies throughout the community in Calgary. James enjoys time with his family and his son, and he likes hiking and traveling. Is that right? Absolutely. Awesome. Yeah. As long as we get there in good time. Yeah. So why don't we give him a warm hand, and online viewers, you can give a little clap emoji if that's your thing, and we'll welcome James to the stage.
Yeah. Appreciate it. Send a thanks to Southview for hosting it. Of course, yourselves for attending and making your way here tonight on a frosty evening. And all the Zoomers online too. So thank you for having me. We are going to talk about where there's a will, there's a way. And it's really a conversation that we can have now with an intimate group here, which is nice, around the types of steps that one would take in order to establish key decisions and key controls, I guess, in your estate plan around having key documents, right? Estate documents that are important, and the measures that one would consider to fund your estate or to protect your estate or to protect your loved ones, right? So that's what we're going to sort of touch on today. I should say too, I'm not an estate law professional. Like, I don't have a legal degree, I don't have license at the bar or anything like that, but as a CFP, I do touch a lot of client cases through the course of my career, and I'm talking about estates and estate planning probably on a daily basis with my clients. So this is, as Josh said, this is a bit of background on me. I won't spend a ton of time on it, but yes, 9 years with Sun Life. I run a company there, a financial planning practice there, and that's been a great journey. I spent some time in banking at a big bank, at a small bank. I've even spent some time in brokerages when I was a high school guy. I was a courier and helped some of the brokers there at the time. So yeah, I have a business and finance background, and I really have a heart for families sort of getting these things established. So I think let's talk a little bit about the importance of having a plan today. Before I do that, maybe for the people that are here, I wanted to ask sort of what drove you to sort of register tonight? Like, what brought you here, and maybe what are you hoping to get out of tonight? Did anybody want to comment or share an insight there? Cool. I hope so. What about this topic is sort of interesting to you at this point, maybe? I'd love some feedback. Okay. So for the benefit of Zoomers, I think you're basically saying the feedback in the audience is that we've done a will in the past. we want to know whether or not there's been any changes in the legal environment that may precipitate a need to review it. That might be one of the things on your mind. Is that fair to say? Perfect. I think we can touch on that a little bit. I hope this is conversational because it is an intimate group, so feel free to jump in anytime with your questions, okay? But yes, important to have a plan. I don't know if this is, this diagram is going to be on the Zoom yet, or maybe it'll be on the recording, but this is fundamentally how, when I coach clients about building a financial plan, I'm examining things like, I'm asking them, in my fact find with new clients or new people in the community I'm meeting, I'm asking them, what are your goals in the first place? Like, it's your plan, it can't be my plan, right? Because I have my own plan, right? So this is your plan. So what are short-term, long-term, and medium-term goals that you have as an individual, as a couple? I'm also asking, and I'm helping them articulate that. And it's okay if you don't know how to articulate that, because we don't often think about this stuff all the time. So I'm helping them draft and articulate goals because that's what's driving the success of the plan going forward. Then I'm trying to find out, okay, what is the current status of the cash flow that they have, right? We all have inflow and outflow of resources, and my job is to try and see if I can help them optimize that and have a system in place for that. But also I'm looking at their net worth too, right? Which is your assets minus your debts. I'm not sure if I'm on the camera now, but assets minus debt, and the quality of the structure of your assets, and if you have any debts, how are they managed, and how can we sort of make them retire too. So I sort of do some work to do some fact finding at the beginning. Where are you at today? And then tonight what we're talking mainly about is this will and power of attorney area, and we will touch on non-controllable events as well. And so I really believe in having a really strong defensive foundation at the base of your plan and address these key areas. Just as if you were building like a hockey team or a soccer team or like a house. If you're a house builder, you're always going to build a strong foundation at the base, right? Does that make sense? Yeah? Okay. And then, you know, for people that have a lot of confidence at sort of the ground floors of the plan, then of course their questions tend to gravitate to the more offensive areas of the plan and the growth areas of the plan, so everyone's at a different spot with that. But you can kind of see how the diagram spirals a little bit too. And I think that's important because financial planning isn't really a static sort of discussion. It is something that you and your advisors, and your partners and your stakeholders will have an ongoing sort of feedback loop, right? As you said, there's changes in your life that happen. There's changes in the environment around us. Even this pandemic has sort of exposed and has disrupted many of us in many ways. And so it probably precipitates a plan review periodically. Okay? Oops. So maybe I'll ask a question. This is fun. So trivia. So can anybody think of some famous people in the last several years that unfortunately have passed away and have done so without a proper will in place? Any names come to mind? Anything in the news? No? Okay. So I just did a Google search yesterday about this, and the ones that come to mind for me were Prince, the music artist, Prince. Can you imagine the licenses that he has on all of his song record, like his songwriting and creative music initiatives over the years, and for some reason there was no legal will. To me, I'm struck by that, and it makes me wonder, you know, was there something going on inside that individual that maybe they didn't know what to do, or they didn't ask, or maybe they didn't trust, or maybe it just didn't come up. Michael Jackson apparently didn't have a will initially when he first passed, but they later found one. Aretha Franklin, the famous soul singer, didn't have a will. And so even sort of these cultural icons, these people that are extremely successful in business and in creative efforts, some of them have not done this type of work. So this is a safe place tonight. If it's something that hasn't been done in your life, it's okay. My encouragement, I think, tonight is to try and move you an inch further toward getting one done or redrafted or revised. But what is a will in the first place? So it says here, a will can provide the security of knowing your wishes will be carried out through after you pass away. So it is a key estate document where you have the control and the power to name an executor, which we'll talk about, someone who handles your estate, and you'll name a primary and a backup. A will tells people in charge of your assets how to distribute them. So not just your financial assets, but maybe even your personal effects. Nowadays, the discussion is around, like, what do we do with our social media? What do we do with our digital credentials as well? What happens, it deals with, if we die without a will, your assets will be distributed according to the law. So I guess the question I would have for the audience and the Zoomers is, think about your own situation. If you didn't have the legal document in place that sort of is very clear around these things, are you okay with the courts sort of being the dictator or the decision maker as to what happens with your affairs, right? So that's one key reason why people would move forward with one. And then, of course, another tip is keep the will in a safe place. I've heard lots of unique ideas about where to keep it. Basically, a copy goes to your lawyer if you've done it through a lawyer. Some people do it themselves, of course, too. There's such a thing as a holographic will. A holographic will is like a handwritten will, right? Which may or may not sort of hold up in court. It would depend on how it was written and how it was sort of witnessed and how it was sort of dated and constructed. But I do think that if you're going to go down the road of getting this done, that you do it through a proper estate law professional. And we can talk about costs if that's one of your questions. But to keep it in a safe place once you've actually gone through the process of completing it. So, we've got a question. Yeah. You bring up a couple of points there. Thank you for sharing that. So first of all, accessibility, right? And so obviously when the day comes, we want to make sure that someone that we trust knows about where it is and how to get access to it. So obviously safety, because it is obviously confidential and it's personal to you. So whether you sort of retain a safety deposit box at a bank, that's one way. I did have a client this morning that mentioned that that's where she puts hers, but she also said that her son has a joint access or key to that, and they talk quite frequently, and so that's okay, right? I think that's good. I think you can even deduct the safety deposit box fee on your taxes because it's like a carrying charge of holding your important papers there. Home safes, obviously. Anywhere, basically, if it can be fireproof. A freezer, believe it or not, is a tip. You can sort of like put it in one of these freezer bags or whatever and tuck it right in the back. I've heard people do that too. Because, eventually the freezer has to be cleaned out. And so it will be found. If the house burns down, well, no, of course not. No. I would agree. Yeah. I would say that's probably the most popular and probably best choice, as long as the people around you that you trust know it's there and can access it when the day comes, for sure. So I could tell a story of maybe what not to do from my personal life. I went through a life event a few years ago, and I was pretty bummed out through this event. And a friend of mine noticed I was a little bit bummed out and decided, and he was a pilot for like a small, I guess the Springbank airport out here where they fly the Cessnas and they do training and stuff. And I had a will in place for years, and I had the peace of mind and the security up here and here because my situation was basically stable up to that point. And then when this life event occurred, it really disrupted me. And I have a son. And he says to me, James, you know what? You need to get out of your headspace. You need to come with me. We'll go up for a short flight on a Cessna, and we'll go out to Didsbury, and we'll come back. It'll be a nighttime flight. You'll sort of get out of your headspace, and maybe it'll encourage you. And I said, you know what? I think I'm okay. And he was persistent, and after about 3 times of asking me, I did go. And then I get there, and then of course I'm not a good flyer, and I'm especially not a good flyer if it's like a small 6-person aircraft or whatever. And I says to him in the airport, I said, his name is Jason. I said, you know, Jason, it's been going through my head, like, what happens if something happens to you? You're the expert. You're the one that charters people around the world. You've flown executives. You've done all these hours in flying. But what happens if something happens to you? Like, do I literally have to, like, land this plane? It's this dumb question, right? But it was like sort of the irrational fears are going through my head. And then he's like, yep, and you know, the air traffic control will sort of bring you down, and they will sort of like give you the step-by-step instructions about what buttons to push and how to like, and I'm just like, I can't do this. But I get in the plane, I go ahead with it because you know what, you got to step out. And he was so good about it. Anyways, in the airport, before we get into the airplane, and he is so safe, right? Like he is walking me through, he's so sensitive about it. I am literally texting my lawyer, I, James Bilcox, hereby bequeath my full estate to da-da-da-da-da, and I name this person as my executor, and I name, you know, and the residual of my estate goes to here, and this is the guardian for my child, and this is the trustee for my child. And I literally had like a text like this, and you know how you like run out of characters eventually in your text? Well, that's what happened to me. And my lawyer politely responded back after I sent it. She goes, "This is not a will." And I can't enforce this in a court if something did happen to you. I'm like, I'm really scared. So don't do that. But you can see how sometimes your peace gets disrupted when you're going through life events, and maybe irrational fears can sort of trigger it. But hopefully in your case, you guys have like rational thoughts about being intentional and about making plans with your stakeholders to get these things done. So don't maybe do what I did in that case. But I did go to the lawyer like 3 days later and got the will done properly. And then I felt a lot better. So I put a lot of credence in the power of a will to settle myself. And I don't know if you feel similarly, but to settle myself. And it gives me a runway of like, okay, I know life is going to be sort of ups and downs. There's going to be challenges. There's going to be changes. But basically that document is now a framework for me to sort of walk more confidently in my financial life, I guess. So we're going to touch on executor. What I wanted to maybe ask about that. Has anybody been an executor here before? Yeah? You've been an executor? Are you open to sharing a little bit about that experience?
Well, it's, I didn't have to worry about, I mean, technically I have to sign things once in a while, but my brother's a co-executive.
Mm-hmm.
My brother's a state, he's
Okay.
a chartered financial analyst, and has been for, you know, over a couple decades, so he knows how to deal with it all, and all I have to do is sign things once in a while.
Okay. So maybe in your case, you're named as a co-executorship, a co-authority over the estate. And in your case, maybe the heavier lifting is being sort of run by someone else, the other executor?
My brother can take care of any
Okay.
technical stuff. I mean,
Okay.
a financial professional, you know,
Fair enough.
sign whatever he tells me to sign.
Fair enough, yeah. So has anybody else been named an executor or had to act as an executor? No? Okay. Well, it's sort of an honor in a way, right? Because someone trusts you and someone cares about you and thinks well enough of you that would name you for such an important stewardship responsibility, of course. But over time, I think what's happened is that the financial landscape has become so complex, and our lives are fast-paced and complex sometimes too, that sometimes being named an executor and being launched into action to do these very important duties is overwhelming potentially, depending on who you are and where you're at and how complex the estate is. But number one, some tips on this is they should definitely be someone who's trustworthy, of course. So you talked about that. I didn't catch your name, sorry, sir. Andrew talked about that. So there was like a chartered financial analyst in the family that was named an executor. Well, that person has, you know, high financial acumen and business acumen, and you also have your own skills, right? And maybe you have your own vigilance and due diligence with the estate settlement as well. So we want someone who's trustworthy. We want someone who's willing to do it. You know, my own father and mom asked me to be an executor, and they asked my brother and I to sort of be co-executor. They might have changed it since then. Maybe they've had rethoughts. I don't know. Now I'm in the financial world. My brother is like a freight broker, and in the business world, we're both busy family guys, but these are the natural sort of executors that maybe parents would think about, right? The issue is that, and they can do what they want. It's their decision, and I will dutifully act upon it when it comes time. But my brother's in Chicago, Illinois, with his family. I'm here in Calgary, Alberta. We're both busy guys. Co-executorship is sometimes tricky. I don't know, maybe you didn't have much of an issue with it?
Even with our mother, we still have an estate account. She died almost 5 years ago. But in some cases, it's just useful. Anyway, in our case, to keep the estate.
Sure.
But no, even when she was alive, I was her personal director. He was her enduring power of attorney. He lives in Minnesota. He can manage all of her finances, online. And then I live physically in Calgary where she was, so I could manage her personal and medical needs because I'm personally here to do that. So it got split that way.
Okay. Good communication.
Over financial matters at all.
Good. Well, that's another thing. So I'm glad that your story sort of has good communication and not a lot of family sort of dynamics that are infighting and such. So someone who's willing to act, okay, because there's a primary executor, the authority over the estate, and then there's a contingent. You name a backup or a backup one, okay? When the time comes, you never know where that person's going to be at and whether they're willing to do it. So the lawyer will ask you to provide backups, right? We want someone with good financial acumen and business sense, ideally. Maybe there's people in your stakeholder group in your family that you're thinking of even right now. There is provision in the will typically to sort of compensate the executor too. And when I've talked with my lawyer, they said it's something like, a general rule of thumb is maybe 3% of the estate. I've seen as high as, say, 5% of the estate or more. I've seen, go ahead, yeah.
But often your executor's your heir as well.
That's right. Sometimes, yeah.
You're getting it anyway.
Right.
One way or another.
Yeah, so whether it's sort of an itemized thing, specified in your will, or if it's sort of dealt with through the distribution of assets, chances are they're going to be sort of compensated for the time in.
Tax purposes, it might be.
So for the benefit of the Zoomers, your question is around, you can name a co-executor, and to what extent can they act equitably? Is that maybe your question? Yes. 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 Yeah, you can definitely name co-executorship as primary co-executorship. That's what's, like, even in the example I gave of my own family, that's what they've did for me. They've asked me and my brother to do that. And so then it becomes sort of I never lived through it, and it sounds like you have lived through it, like where you actually acted as a co-executor, and it sounds like it was a pretty good case where
Still technically.
the bulk of the work will probably be done by an executor in the first, 1 to 2 years, I would say, 1 to 2 tax years. But depending on the complexity of their estate, maybe how they earned a living or how they earned income, there could be sort of passive income or residual income that trickles into the estate or is discovered later. Is that what you're sort of getting at? Like that there's checks that come later potentially? So eventually the executor will have sort of completed their tax responsibilities and their other executor duties as far as distribution of assets, and then there will be sort of a probate process typically, not always, and then there's a clearance certificate that is sort of issued by the Canada Revenue Agency once they are sort of satisfied that the estate is tax compliant, and then that's typically when assets can freely move from the estate into the heirs. Right. Yeah, there could be reasons in the best interest of the estate to sort of take time with that, right, and decide the timing in the best interest of the estate for sure, and those that are, to be in receipt of it. So let's pivot now to power of attorney. There's there is some sort of myths around this, or maybe some misconceptions around this, but there's enduring power of attorney. So that would be for your property and financial decisions, okay? And first of all, these are documents that are in place while you're alive. The powers that are sort of put into the document end at passing, whereas the will starts at passing onward, okay? The enduring power of attorney is to do with who do you want to become you in law to handle your property decisions and your financial decisions if you become incapacitated. So there's usually a triggering clause inside of the document that says, you know, if this donor client becomes incapacitated and is diagnosed by maybe one or two physicians that this is the case, then the document is triggered into force. And then the attorney, whoever you've named, will become you essentially in law to handle your property and financial affairs. Now, they can't do carte blanche whatever they'd like. You know, it is very sort of in the best interests of the donor client. And I think this is an area where sometimes there is abuse. From time to time, I've seen it over my career. Most of the time, I would say the attorneys that are acting on behalf of the donor are handling it with a strong duty of care. And they obviously care about that person, and they want to take care of those resources for their best interest, and of course for the end estate later on too. But that's the enduring power of attorney. Then there's personal care or personal health care directive, which is more to do with your healthcare decisions and who you want to name as your authority, who becomes you if you are incapacitated and you would like certain healthcare decisions to be made, right? So I guess for an example would be, my lawyer asked me to what extent do I want to, if I'm sort of in a vegetative state, what do I want for myself? And they asked me, to what extent am I okay with the use of pain medications to sort of ease or make myself more comfortable if I'm sort of in a palliative state? So those kinds of things are discussed in a personal health directive. Any questions on those? Yeah, go ahead. Yeah, I would say, I don't know your situation, but I would say it's common for partners to name each other as attorneys over each other in terms of the enduring power of attorney and the health directive. And even to name, as an executor on your will too. It's common to see that. There might be reasons why you don't do that in your personal situation. Does that help? It's common, like I see it a lot. So this is actually one of the things that I actually emailed my lawyer about stories ahead of the talk. She actually talks about this. And I'll maybe reference her by quote. Often spouses assume that their partner will be able to step in and make decisions for the other in the case of incapacity, without the need for a personal directive or an enduring power of attorney. A spouse may be able to assist in some urgent personal decisions or financial matters where they are joint account holders, but without the personal directive and the enduring power of attorney, they cannot, among other things, A, get someone into long-term care, B, sell a home in which they are both registered owners, C, deal with accounts that are in the spouse's name alone. She says further, they would need to go through many months long and expensive process of getting a court order giving them guardianship and trusteeship instead. So yes, I am strongly encouraging take the intentional effort of getting those documents in writing through an estate law professional custom to your financial situation and your preferences. Do not, if you want sort of an airtight piece on this issue at an even point, that's what I would encourage. How you name, who you name is sort of up to you, right? In your personal situation, who you want. But without it, it's sort of ambiguous. Even as partners, you would think, right? Oh, well, that's my partner and I'm bedridden in a hospital due to a trauma or emergency. Well, there's my partner right there. The doctor's letting me in for the room. So yes, I think common sense should prevail for urgent care needs, right? But it comes to more of the bigger decisions maybe after I think that's where there's going to be an issue potentially. Go ahead, yeah.
directives.
Okay, so for the benefit of the Zoomers, the gentleman was asking about, is it easy or should we or how do we put on backup or contingent named people in our enduring power of attorney and our personal health directive? So the answer to you, yes. Like right in the document, you'll be asked, when you do your intake form with your estate lawyer, before you even meet probably, they'll ask you like, based on your current headset today, who's your primary and who's your contingent. That's the language they might use, or backup. And yes, you definitely want, they're gonna not make you, but they're gonna ask you and encourage you strongly to put a backup there, okay? Yeah, it may or may not be an easy dynamic there. But yes, they will encourage you to sort of think of a backup to your point. But I've never, I'm not at that place where I maybe have that dilemma where I'm like, who is my son ready? No, of course not. He's not ready. But like later on, if I'm say in my 70s or 80s or something like that, would he be ready? Well, probably, right? You'd have to look at that. Okay, so those documents sort of are, well, they're so key. So those are the three sort of main ones that an estate lawyer would encourage you to do in one sitting. The cost, I've like the lawyer that I run with and the package they do for sort of mirror image, like when I say mirror image, like both partners in a coupleship sort of have similar mirror image plans, right? Where it's fairly boilerplate and fairly straightforward for the lawyer. It was, for all three, it might be 700 or 750. I mean, to me, what is your peace of mind worth, right? Like, I love not thinking about this stuff. I love walking confidently and not thinking about this stuff until there's a moment of disruption, and then I got to go deal with it, right? And I'm coming up on one of those moments too, which we might touch on. Actually, yeah, plans change, right? So, as an example, like I'm sort of in sort of a discussion around changes in my business, and it's causing me to think about, well, should I revisit my will to address objectives that I have in my business? Because before there was no corporation, now there is. So can you give me some examples of some life events that would probably cause you to think about possibly creating a will, revising a will, updating one? What would be some common life events that hit you? A car accident. So some sort of jarring trauma would probably be a big enough event that you'd want to revisit this, I would think. If you didn't already have it in place, you'd maybe want to address it again, or at least pull it out of the drawer and read it again. Right? When we come to grips with sort of some sort of jarring moment that is we're thinking about our own mortality, then I think that's an obvious one for sure. Anything else that you're thinking of? Right. So it's, we're seeing maybe that happen around us. Those are important relationships to us. Maybe are you thinking of like what you're noticing or observing after they pass, and it's causing you to rethink, okay, maybe I would like to have something different for my situation? Is that what you mean? Or like relationships, people you've named as heirs or people you've named as authorities are not with us anymore. When did that happen for us? I know the day it happened for me. Do you remember when that crossed your frame of reference, when you didn't feel invincible anymore? Yeah. So that is definitely one where maybe there's been a passing, and that maybe causes us to think about it. Anything else that's top of mind? Maybe there's a child or grandchild. That would absolutely be one, right? I believe that is true, where like, let's say you had a 50% share to an individual, they predecease you, that it may sort of trickle down into that family unit or that part of the family tree. Not always, but I would say this is a reason to pull the...
it says. If my brother predeceased.
Yeah, like if it says, yeah, I'm pretty sure that in my own, it literally goes into sort of multi-generational trickle down. But like definitely read the will. Like if you have one in place, you said you had like 20 years or something has passed. I mean, how many changes have occurred in your own lives? And to your point, like what has changed in the legal environment as well, potentially here in Alberta as a resident. You may have assets in other jurisdictions where tax laws or estate laws have been revised over time. If you have foreign property too, those would be other sort of nuances. But so keep your will current. I would say every 3 to 5 years, pull it out of the drawer, maybe, I don't know, have a glass of wine with your partner, pull it out, put it on the kitchen table, read it literally line by line would be good, dust it off. But if you're doing minor changes, like I had emailed my lawyer yesterday and said like, hey, you know, my business is, this is what I'm thinking, there might be some changes, blah, blah, blah. Is this warrant an update? And she said, well, the way your will's written, it sort of already addresses your future business or corporation, so maybe not. So I might drill down on there with her. But there's such a thing as a codicil, which is like another word for like an amendment to your will. So you don't necessarily have to like fully update the whole will document framework, but maybe just just an amendment. A major change will revoke the old will, which is I've had a situation where I definitely wanted that. You know, there was no peace anymore under the old will. I definitely wanted a new will, and for the very purpose of revoking an old will, right? Any questions on any of that? I think that question is probably better answered by an estate law professional. Like the question again was essentially you're framing a question around, you know, we have a will in a certain jurisdiction. You know, if we've moved to another jurisdiction, is it smart or wise or even needed to do an update in the local jurisdiction? I would say generally, if your estate is going to be here, let's say in Alberta, most of your home, you know, other property, maybe your investments are based in accounts here, you know, most of your estate should you know, be settled here, then yes, like, you know, now there's times where you need to almost have a second will in another jurisdiction dealing with a separate asset in another jurisdiction. Like we have the common theme is sometimes we have people that base themselves here because they sort of raised their family, were employed here many years, retiring here as their sort of home base because of amenities, quality of life, whatever the reason, family. But then they have sort of a secondary property in another jurisdiction like Ontario or BC or in the States or something. And depending on like how significant that asset is to the legacy of the estate and maybe the tax jurisdiction that it resides in, then it may precipitate its own will specifically on that. Not always, but so I'm not sure if I'm touching on answering your question really clearly, but I would say for sure estate law advice in a personal situation like that or a personal question like that. I don't know if I can, I'm not trying to skirt it, but I would, in my personal situation, I probably would feel better if I had an updated will for where the majority of my assets are housed, right? Because each provincial jurisdiction sort of has its own tax law and its own sort of estate process, right? So does that, I'm not sure if that helps, but okay. Marriage automatically revokes an existing will unless written specifically in contemplation of marriage. Divorce may alter the distribution but does not revoke the will. That was my life event earlier that I was talking about. Peace was not there, so I had to update it. So naming a beneficiary. So when I'm meeting people, one of the first things I'm doing is I'm looking, okay, like on your different investment accounts and how you build your plan, who are you naming? Not so much who, but like what is the makeup of your beneficiary selection? Like what it is, obviously it's going to accomplish maybe some sort of personal desire outcome you're seeking, but then I would probably ask the question of like, okay, if this plays out, how does it get sort of tax treated is another thing. So we can't make all the decisions in the vacuum of a tax discussion, but I am definitely encouraging you, maybe later this week, go through your investment account portfolios that have named beneficiary and double check what you've done or named, right? So I don't know, maybe I can write on the board, but just to give example, but so there's like retirement savings plans, right? That's one bucket that people often have, and those change into, maybe when retirement, they change into registered retirement income fund buckets, right? Or registered annuity buckets. Then we have tax-free savings. Then we have what happens to our primary residence. I guess maybe secondary property. Sorry, I'll get out of the way in a sec. Yeah. Then we have, like, I don't know, non-registered investments and savings. Maybe I'll leave it there. And maybe like life insurance. So just quickly, because I think we're going to run into time constraints, but RSP, the beneficiary, if you're a sort of common law or married partner, commonly and recommended that you name each other for tax deferred rollover of those assets for your surviving loved one, okay? But what I sometimes see is I'll see like 50% named to spouse, and then I'll see like kids named in primary spot. And what's going to happen there is that the 50% will go to a spouse tax deferred, because that's what the CRA will permit. And then the other 25% is going to kids, let's say. It's going to get taxed and erode the estate value and maybe even put a tax burden on the child, the adult child, let's say. So it's common to see that. TFSA, tax-free savings account. So if you're a common law or married partner, again, the recommendation is usually name your partner as a successor annuitant. That's the language that they will use at your financial institution, okay? There is also a beneficiary designation, which is slightly different. But if you're a married common law successor annuitant, because then what happens is the tax-free asset will roll to that successor, as it is, and it will not affect your tax-free savings account room as a survivor. Home, primary residence. For now, we have we've had a primary residence tax exemption when you sell your property, your principal residence, right? Now, I find it interesting that they're now recording things like, what did you purchase your house for, on what date, when you file your tax return. So I don't know if they're collecting that info for just a census or if they're collecting it for future use to determine a baseline value of your home when you bought it, so that when they find out when you sell it, maybe they can do something with it. We'll see. But for now, a home is a tax-exempt asset when you sell it, or if it goes into the estate, it's a tax-free asset. But it will be part of the estate and dealt with through the will if it's not sold ahead of time. Secondary property, like a cabin or a cottage or recreational property or rental property, those are all treated like taxable assets when they're sold, okay? Non-registered, same thing. It'll depend on how you're invested, whether you're in sort of interest-bearing accounts or dividend paying or capital gains. That'll depend on the tax treatment there. But you can name beneficiaries on these types. Not typically through a bank, though. Through an insurance company, non-registered assets can have a named beneficiary through products like segregated funds and things like that, annuity products. Life insurance in Canada, life insurance payouts are tax-free to your named beneficiary, fairly privately, quickly. So address your life insurance beneficiaries and make sure they're up to date as well. But a tax-free right to them, it goes outside the estate. I had an estate last week with 3 adult professional children, sort of an 84-year-old mom who passed. I was like, she did a really good job. I believe her home might have been sold ahead of time, but then the monies were sort of invested in non-registered vehicles. She put it in like an insurance sort of program where she could put named beneficiaries on it. And so a large chunk of her estate went directly to those 3 kids outside of a will. Just like direct, like I did the claim form, right to them. Within about 30 days, those heirs were receiving most of the mother's estate privately. And then a tax-free account, it had beneficiaries as well. So it was just a very quick claim, okay? Go ahead. Yeah, I'd have to see the situation. I mean, it's not uncommon for like a parent who's thinking about their estate affairs to maybe put someone joint on their estate assets or homes or properties. I'm careful with that. I'm not necessarily encouraging it, but I'd have to see the situation. There's probably good reason to do it. There's tenants in common and joint tenancy. Those are two different legal methods of creating, I guess, beneficial ownership there. But I think that is sort of outside of my scope for tonight. Yeah, again, I've seen lots of scenarios where joint setups on title can work, and some where it sort of complicates affairs too. So naming a beneficiary outside your will. So I gave you an example of like a client who had an annuity product at an insurance company where it had a named beneficiary and it went directly to those named heirs outside of the will. That can be a very easy way to pass assets to the next generation privately and quietly, quickly. We talked about backup beneficiaries already. Check your beneficiaries regularly. You have a question? Yeah. So when the government brought out tax-free savings accounts as a concept, as a structure for Canadians to save in the so the financial institution that's opening your contract will ask you, like your, I guess, your relationship status, right? And if you're sort of common law or married, the recommendation that most financial advisors would say in that case is name your successor annuitant as a spouse. You're asking the difference of successor annuitant versus beneficiary? Yeah. So it's particular. I think it's particular to tax-free savings accounts. So in the very concept itself, it's tax-free growth of assets forevermore in perpetuity, right? That's sort of the benefit of a TFSA. But successor is like you use that very specifically as a common law partner or married spouse. That's the authority that one should consider doing there. Yeah, because the theory is that there's a surviving spouse, and then those assets will transfer to that surviving spouse as they are. So even the underlying investments of the TFSA contract will move over to the successor spouse, survivor. Whereas if you've named beneficiary, it might actually end up accomplishing the same end aim of getting the assets to the survivor, but what will happen is the TFSA will actually collapse. The investments will be sold, and then the cash will be like literally written as a check to that person. And then they can do whatever they want with it. So if you want to sort of maintain the tax efficiency of the concept through survivorship there, then name successor annuitant. And then that means that the survivor can always change those investments later if they don't suit that person's investor profile for the rest of their days, right? And they can still extract those dollars at will if they need lifestyle or whatever. But so that's a way. So you had a question too? Right. So when someone passes, pretty much any financial institution is going to want proof of passing, and sometimes they will also ask for the last will and testament. They will ask for identification. They will want to speak with an executor or the claimant. The claimant might be executor. They might also be a beneficiary of the estate. They're not going to do that procedure or transaction automatically, typically. Yeah, they probably won't do that ever automatically. There will be a normal sort of estate settlement process, paperwork, logistics to sort of the bank or the financial institution, the insurance company will do their due diligence, and then if that is sort of the successor is named, then it would roll like after. But that would be how it would move, okay? Yeah, so you guys have worked with banks and insurance companies, financial boutiques. We love our clients, we want to help our clients, but there is sort of like an estate process that sort of we get followed there. I want to watch time here, but so, okay. Let's say you've built like your will, your power of attorney, your personal health directive, you're feeling really confident, you're really feeling secure. Then it's a matter of like, how do we address survivorship needs, right? So you're going to have a certain amount of your net worth is going to easily translate to your survivor, right? Like registered accounts, non-registered accounts, home property, secondary, like those things will transfer in time in due course with the estate settlement process if that's what you've directed. But really, when I'm looking at it with people, like when they come in and they're wondering if there's a gap in their plan here financially, I'm asking them, okay, what are the immediate cash needs of the survivor if you're not here, right? And then I'm looking at what are some of the long-term income needs and what is already available to determine whether or not there's a shortfall. Make sense, right? When it comes to funding your long-term needs, some of you may have paid into defined contribution pension plans over the years or defined benefit pension plans over the years. And if you happen to be married at the time of a passing, again, check beneficiaries and check your pension income settlement, how you decided when you triggered your pension income. You know, did you do a joint 100? Meaning, if something happens to the primary pensioner, does the survivor get the same benefit for the rest of their days, or do they get some percentage of the benefit? So sometimes it's joint 100, sometimes it's joint 100, 2/3, or sometimes it's single life. So if you have a pension, you'll get a better pension income if you chose single life, but when you pass, that's it, right? So check, if you haven't engaged your income stream on some of your employer pensions yet, maybe have a consultation with your financial advisor about what is the best thing for you. Government assistance, we've seen a lot of government relief programs over the last couple of years, but I'm thinking mainly of like funding long-term needs. There is a Canada Pension Plan life insurance benefit, believe it or not. So we've all paid into Canada Pension Plan for years, right? There is up to $2,500 of life insurance. Don't get out of your chairs too fast there. There's $2,500 available from Canada Pension Plan when somebody passes away because by the virtue of been paying into CPP all those years, okay? So make sure if something happens, that gets applied for. Survivor's income, how do we fund that? Well, it's going to be funded by your assets that you've left, or it's going to be funded maybe by things like life insurance, right? Short-term needs. So these are some of the things that people are sort of thinking about usually when when someone's passed, right? I want to make sure that taxes owing on my passing are addressed. I think this is the one that's the biggest misnomer for people. When I look at their financial plan, I run estate projections and I find out, okay, how do their assets project over time, over a long arc of time? And what happens if the last spouse is now gone in a partnership? That's when the CRA is going to come looking for what they can sort of tax at what they call terminal income tax. And I can maybe use these buckets again, but basically any money left over in RSPs or registered retirement income funds or life income funds, whatever's left in the survivor's hands and then second death of spouse is coming into income in the year of passing. And that can be sort of alarming maybe when you first hear it or if you see the math on your own estate. So I would say enjoy your income in your own life, especially in these vehicles. Again, TFSA is a tax-free home, tax-exempt asset when sold or brought into the estate. It should be tax-free. But get your financial advisor to run an estate projection to see, okay, if I draw this much retirement income over, say, from 65 to 95, what is going to be left and where is it going to be left in? And see if there's a tax owing at passing. And that might not be a concern for you, but at least you should know about it. And then you can maybe try to address it with some pre-planning. Funeral expenses. What's the average cost of a funeral probably in Canada these days? What do you think? I would say the average is around $15K to have some sort of funeral memorial. It sort of depends on what your preferences are, cremation or burial, right? So the point is here is that, is this addressed in your plan? Like you said, maybe it's prepaid. Awesome, check mark. Sometimes it's not prepaid, so then that money needs to come from somewhere within, 30 days or something. So there needs to be some liquid cash in the estate, in your affairs to sort of deal with that. Lawyer executor fees. Whenever I do a survivorship analysis, I use 5 or 10,000 as sort of a legal fee potentially. I high side it maybe. Executor fees, we talked a little bit about that. Maybe 3 to 5% of the estate should be assumed. Probate fees. So in Alberta, we have the lowest probate fees in the country for now. There was talk for a while there to sort of revisit the probate system in Alberta. Maybe that's on the bench for a while, but it's $525 is the maximum probate fee in Alberta. Other jurisdictions in Canada have sort of more of a graduated, tiered approach as to what the end probate cost would be to the estate, and they are significantly more potentially. Yes, we need capital potentially we need capital in the estate that can deal with mortgages, loans, whether they be on a primary or rental property, let's say. Does it have to be paid out right away? Not always, right? Maybe there's a very good reason for a mortgage to be left on a rental property asset for a period of time after a person's gone. Special bequests. I have one client who, a very generous client, and had very specific individuals and charitable causes they wanted named on their life insurance, right? I was like impressed. It was a little bit of work, but I'm so glad that she is settled and has peace about it. But yes, you can sort of there's going to have to be capital in there for special sort of amounts you want to make sure to go to particular individuals. If you're a business owner, maybe you're in a partnership with someone, how do we address a buy-sell agreement? How do we fund a buy-sell agreement? When a partner passes away, how does that exit happen, financially speaking? Emergency proceeds. I usually tell couples, think about having 6 or 12 months of whatever you spend as sort of a baseline for an emergency or transition fund. Because that's like the last thing we want to think about when someone's passed, right? Like we want to go through the normal human grieving process, however long that may be for a person, and we still have bills coming. Credit cards and debt repayment, of course, that needs to go away, hopefully right away. When I show up with a life insurance check, I want to make sure I'm showing up with the right amount, and I'm going to ask that surviving family, okay, how do you want to deal with this? Do we want to clear off personal debts? Do we want to allocate some money for emergencies? Are there anybody that needs money right away? And then talk about investment of whatever's left for maybe their income needs, those longer term income needs. The thing with interest rates so low right now is that whatever you thought you should probably have for life insurance, consider revisiting it because interest rates are so low. Now they're starting to tick up higher. We just saw the Bank of Canada raise them yesterday. But the point is if you have a residual amount of money left over from, say, a life insurance policy for the benefit of a survivor, you want to reinvest it for a period of time and develop some income for that person, right? But if it's at a conservative investment like 1 or 2%, it's not going to yield much of a survivor income for that person. So you might need to have more life insurance to address the survivor income problem. So there's a common credit card arrangement where there's a primary owner or applicant, and then sometimes we make it joint with a partner or spouse. Those people are co-liable for the use of the card and the debt, right? But I think you're asking about like does that joint user have authority over the credit card and its usage after passing? I think what happens there is that, of course, so the problem is normally the survivor may not have their own credit history in their own name, or not. It might not be robust enough, and they might need access to credit after their spouse is gone. So now that's one issue, is that if you're a joint user, man or woman, if you're a joint user on a credit card, you may not have your own sort of reported credit history on that card, right? And that can be problematic. Yeah, like when I was at the bank, you're right. The joint user, they may be co-liable for the debt, but they're not necessarily primary authority over the account. So if the primary authority passes away, then that sort of leaves the joint owner in the loop there. Financially, like the debt may still be owed, but also you don't necessarily have access to run the account like you would have. So, yes, I love that. Yeah. Yeah, so to the extent that you need a sort of convenience credit card, I definitely recommend partners in a marriage or common law own an individually primary held credit card account. They may have a joint account, or maybe they're joint on each other's, but basically for two reasons. You need credit history to report regularly in your own name, and you need access and authority, right, for situations like that. So good tip. Couple minutes left. You had a question? Perfect. Yeah. Separate paper trail for a taxable business asset that needs its own sort of reconciliation, right? And so that makes sense. So let's quickly touch on life insurance. I'm not going to spend too much time on it though. So these are obviously critical structures in your financial plan to make sure that you fund the survivorship needs and some of your legacy intent or your estate intent. Now, there's term life insurance, which is like renting the life insurance benefit. It's not unlike renting a house, right? Like you rent for shelter, and you pay rent for shelter for a period of time, and it has a set cost for a set time. And then often your lease on your rental agreement comes up for renewal. So term life is economical, but it's not always appropriate for every type of objective. It's really good if you're like raising a family in your primary breadwinning years and you have a mortgage and it keeps costs down and you protect your family for a low cost. It's not really great for like estate planning objectives, like passing assets to the next generation or dealing with estate preservation issues, like when the CRA comes calling because you did so well in life stewarding your money. Now there's a tax hit at the end of days, right? And you want to make sure you preserve your estate for your actual loved ones and charitable intent. But basically term life, let's call this money or benefit time. Term life starts out, this is just cost, right? This starts out really sort of inexpensive in the earlier years, and you could do like a 10, 15, 20 year, 30 year, cost predictability, renting arrangement, life insurance for your loved ones, tax-free, named beneficiary, all of that. Great. People don't tend to pass away here, so it's super cheap, right, when we're younger. Term will go up at renewal points, and this is where people sort of have to have that debate as to whether it's wise for their plan or not. And then it'll go on again, right? It'll keep going. Eventually, it gets too expensive and you cancel it, or maybe someone passes, or it just gets so uneconomical that you basically just can't. It doesn't make any cost-benefit analysis anymore, right? So at about 85 is when most term policies basically just expire. But people are living so long these days, right? So it's not helping for this issue out here. So permanent, and so the other thing with term is that there's no cash value. So there's nothing, it's a gift to your loved one. There's nothing intrinsically in there for you as a cash value that grows your net worth or estate, right? Permanent, you might pay more for permanent, and there's a reason, because the insurance company is making a promise for the permanency of your natural life expectancy. That's a much longer time potentially, but this is the cost. It basically just stays level potentially for a period of, potentially for the whole contract, for a set level of life insurance. The other thing with permanent though is that you can have some value accrual in the contract. It might start out at, say, $100,000 of permanent life, but over time it has some dividends being paid into it and some cash values, and the death benefit is growing over time. So you'll have to evaluate that with your financial advisor as to whether that's smart to have some in your own plan. Health insurance solutions. So these are sort of like living benefits where you are the owner of the insurance and you are the recipient of the insurance if something happens, right? So you've heard of critical illness, maybe you've heard of long-term care. Have we seen in the pandemic here sort of the revelation that we have a problem in our country with long-term care? Like the cost of it mainly, and to what extent we can get subsidization from government bodies or not, and the quality potentially. So Some people call this retirement insurance, but I have a long-term care policy and I'm 43 and I don't think I'm retiring anytime soon. So why would a 43-year-old have it? Because like you probably want dignity. You want to maintain your dignity. You want to protect your assets and you don't want to burden your loved ones. So people will reach out for, setting up a long-term care strategy, or retirement insurance, we'll call it, where it protects your nest eggs just in case a person becomes physically dependent or mentally incapacitated and they need long-term care. It's a living benefit paid to you. Critical illness is a little different. There's a whole swath of illnesses that are covered by these types of policies. It is coming in at the time of need, right? A lump sum tax-free cash sum will come into your financial plan at the time of need when you have some sort of a diagnosis of a serious affliction. It becomes uneconomical in certain points of our financial life cycle to have it, but I still think people should start to look at it. Things like cancer, right? Heart attack, stroke, paralysis, acquired brain injury. I had a lady who fell at work and in her working years, and she's a mom, and she had bought a $50,000 policy of critical illness. She had such a bad concussion from her fall that it actually was qualified as an acquired brain injury. And thankfully, she's with us. She's a great mom, great wife. She's still, she has some challenges with focus and reading now because of the effects of a concussion. But the 50,000 I think she had definitely helped her husband come home and be a caregiver to her in a time of real challenge and difficulty. Did it solve all their problems? No. Did it bring her full brain capacity back? No. But it definitely helped bridge the gap between that problem and the other side. Questions on any of that? Not fun, right? But it's important to address these issues. And then disability, I don't know how many people on the Zoom call or here are still sort of actively earning a living. I had a gentleman this week who's early 60s asking me for long-term disability for a 3 or 4 or 5 year period. He just wanted to make sure that if he went down injury or illness, that his financial plan would still be stable. He had a little bit of disability plan through work, and it wasn't enough. He had talked with his buddies at the water cooler. That somebody had a disability at work. They realized, long-term disability was only $1,000 capped out. Well, how can we fund a lifestyle here in Calgary reasonably if that's our protection, right? So he came, he asked, we're going to top it up. So disability is a payment, sort of like income replacement, okay? So I'll wrap it up here. This is chat with your financial advisor, chat with your stakeholders, chat with each other if you're married common law. I encourage draft a will if you haven't already done so. Revise it if need be. Consult your estate professionals. Sometimes we think only the will is the only thing we should do. I do think that the other documents are so critical. So again, enduring power of attorney and personal health directive, and then revisit it regularly as needed. Life events happen, your life is dynamic, okay? And check your beneficiaries, and then review your short and long-term needs, and to the extent that they're well-funded. Thank you to those in attendance for all your great questions and stories. And thank you to those online on Zoom, and thanks to Southview, and again, Community Hub, and Josh Rands for organizing, and Doug for all the tech support. Have a nice evening, and I'll be around for questions. Thank you.
Yeah, so if you guys have any questions, it doesn't look like there's any online yet. Do you guys have any? We have about 5 minutes here. Any in this live questions here for you guys?
You guys were a good group with lots of good questions throughout. So,
I have one. Can you touch on, so for someone who's maybe watching who's single and in their 20s, can you get life insurance? Is that advisable before you're married or common law?
Can you get life insurance before you're married?
Yeah.
You can get life insurance the day you're born. So yes, and often I'll have couples that are starting their lives together, and they may have formalized the relationship or they may not have. but they care about each other, they love one another, and they want to make sure they're protected. So that is something that they will absolutely inquire about before their relationship, say, becomes formalized, I guess. The sooner the better. Insurance it gets more expensive as we age. And of course, our health profile can change too. Like today we're healthy, but tomorrow we don't know, right? So there's a point when a person becomes uninsurable medically. I don't know if that's day 0, like when they're first born, maybe there's something in utero that there's something going on medically, they become uninsurable, or if that's day 73 or something. But yes.
So just clarify, you can do it when you're single, but then once you're married, it just transfers like with premiums and stuff with your spouse?
So life insurance that you bought when you were a single person?
Yeah.
And what happens to it if you become
If you get married, is it just you can put your...
It's part of your portfolio. Like if you bought it privately from a private insurance company, it's part of your insurance portfolio. It needs to be revisited at a life event for sure, like that. But it would flow, if it's privately held, unless you delete it, it would carry on. So it would have to be sort of incorporated into your sort of future financial plan, and you might have to address your life insurance need because of changes in your life at the point of, say, marriage, right? Or say a home is purchased, a mortgage is financed, right? As the owner of a life insurance policy, you get to decide who your beneficiary is. So often it's our loved ones, of course, so then that's when you revisit your beneficiaries. It wouldn't necessarily automatically happen though. Think of your insurance portfolio in a similar fashion as to how you would maybe structure your investments, right? You're going to pick up policies at different time in your life for different needs, for different exchanges or whatever, but I think of mine like a portfolio. Like there's some whole life and universal life for sort of permanent issues and permanent problems and objectives I want to solve, and I've sort of picked them up over time. And then there's like term life, which is super economical and deals with what if crap factor, right? And sometimes I'll keep that, or sometimes I'll ditch that or reduce that depending on how my life changes. So think of it like almost like how you would manage an investment portfolio in that way. Any other questions this evening? You've been a great crowd. Thank you.
Awesome. Well, thank you, James. I don't know if I'm in the camera shot here. Thank you, James, again for coming tonight, guys. Why don't we just give him one final round of applause? And if there's any questions for him, can you stick around for a few minutes afterwards?
Absolutely.
Okay. And for the online viewers, we'll also post the PowerPoint after. So you guys, James's contact info is on there as well. It's on the screen. Yeah. Thanks again.
Thanks so much for your time tonight too, and safe travels home.